My reading of history of man's struggle to find justice, to find his place on this earth, it has been a contestation of a fight between the haves and the have-nots. That's the history of man. And in that struggle, law gets in. Law steps in. To the best of my knowledge, law has never been neutral. It's going to side one way or the other. If law is going to be neutral, then you don't need the law. Sedition Act is a pre-Merdeka legislation that's been left with us. So it's important to understand that this is not something that Parliament promulgated. It's a hand-me-down, it's a legacy from the pre-independence days. But I want to try and take you back a little bit further to understand the very history of sedition. Treason, in fact, is the forerunner to the sedition laws. And as I was saying, it is a contestation. The nobility wanting to maintain the status quo, and it is the attempt to get some space, get some rights, get a life that you find the serfs struggling for. Treason kept them in their place. Treason law. There was nothing you could say, there was nothing you could do. You couldn't challenge the status quo. So in feudal times, it started off with this, the law of treason. It kept you in check. Now the law of treason changed when you had the strength in the monarch weakening. All right, you had the second and the third tier, the lords, the earls, the barons, and the knights, finding that they were now dealing with a king who was no longer as strong as the first. Your power shifts. There was the tussle for power within the state. You had perhaps even from the serfs some coming up, and treason was no longer the law that the king could inflict. It began to move away to notions of seditious libel or criminal libel. Right? Now, as I mentioned, at the time of decision, the absolute monarchy was under threat from rising parliamentarians. Now, by 1641, the monarch lost his place to parliament. Parliament became the order of the day. And by 1704, you have, in the case of R against Tuchin, the justification for sedition. This is what it says. If people should not be called to account for possessing the people with an ill opinion of the government, no government can subsist. For it is very necessary for all governments that the people should have a good opinion of it. Alright? Now, that's your justification for the sedition laws, that the people must have a good opinion. Now, I'll ask you to just observe for a moment that absolute power was moving away slowly from the monarch to the parliamentarians. A shift, if you will. They had displaced the monarch, they had established the parliament, but you must remember that these were part of a body that also enjoyed part of that nobility that they lorded over the serfs previously. So they had tasted it, they had savored absolute power. It was moving from the monarch to parliament. This is a very important early classic definition of what your sedition is. Now note it is 1887. The ones in italics, there are three. That's the second one, to excite His Majesty's subjects to attempt otherwise than by lawful means the alteration of any matter in church or state by law established. I'll give you a simple example of our local context, the Al-Ma'una. If you remember, the Al-Ma'una were charged with waging war with His Majesty. In short, they want to overthrow the government by unlawful means. Now, I took two to cover that sort of situation. To incite any person to commit any crime in disturbance of the peace. Again, it's to maintain the peace of the realm. And the last one, to promote feelings of ill will and hostility between different classes of such subjects. In a democratic society, I think laws to address this sort of situation might be tolerable. The objective rationale being to keep the peace. But if you look at item 1, an intention to bring into hatred or contempt or to excite disaffection against king, government, constitution, House of Parliament, administration of justice, or if you look at the second last, to raise discontent or disaffection among His Majesty's subjects. Now this goes back again to the early days when the king said, you could not criticize me, for the king can do no wrong. So what you had here was interspersed between what might be objectively acceptable provisions that were open to abuse. The reasons these were weaved into the law was to allow for the maintenance of absolute power. 1948, it was already part of the law. It's pre-Merdeka. We inherited. 64, it was extended to Sabah. 69, after the May 13, it was taken to Sarawak. Amended, revised in 1969. It creates 5 distinct offences. To do or attempt to do something which has a seditious tendency, ambiguous. You can read that and it still doesn't tell you what the offence is. After any seditious word, you're still nowhere near understanding what this might mean. Prints, publishes, sells, imports, or possesses any seditious publication. The word seditious does not allow for an objective understanding. You have to go to section 3. Now, there are 6, so there are 2 pages to this here. Bringing into hatred, contempt, excite, disaffection against any ruler and government reads so much like what the 1887 provision had. Excite the subjects. This is again to overthrow, and I think this is the one that I think is quite reasonable. Bring into hatred or contempt or to excite disaffection against the administration of justice in Malaysia or in any state. This means we can't criticize the chief judge for his suggestion that perhaps we should do away with the common law. You might run foul of this, all right? Now, this is precisely what King William I in England in 1066 had in mind. You are not to challenge, you are not to criticize. All right? Now, one has to ask why in 2007 we are having this on our statute books. Raise discontent or disaffection among the subjects of the Agong, the state ruler. This is precisely what treason did not permit in the feudal days. Why are we having it in our statute books? Promote feelings of ill will and hostility between different races or classes of the population of Malaysia. Some of us are beginning to think that perhaps a carefully crafted piece of legislation that might take this on board as a replacement to the Sedition Act is long overdue. The Sedition Act of 1948 is a near replica of the law of sedition that Stephen spoke of in 1887, remembering that that law was crafted to allow Parliament an absolute monopoly over power to still maintain the nobility serfdom distinction. Now, you have to ask yourself whether that distinction, nobility serfdom, still exists in this country, and if you think yes, objectively it does, whether you still want that status quo to remain.